La Cour.
Asseyez-vous, je vous prie.
Please be seated.
Mesdames et messieurs,
Ladies and gentlemen, I declare open the public hearing on admissibility and the merits of the Hirsi and others case versus Italy. The case was brought before the court on the 26th of May 2009 by 11 Somali nationals and 13 Eritrean nationals under Article 34 of the Convention. It was allocated to the second section of the court pursuant to Rule 52, paragraph 1 of the Rules of Court. The application was communicated to the respondent government on the 17th of November 2009. On the 15th of February 2011, a chamber of the second section decided to relinquish jurisdiction to the Grand Chamber.
Thank you. Ms. Shakuchi, you have the floor.
I would like to take a few more minutes to elaborate on the collective expulsions complaint. Our respectful proposition is that the guarantee enshrined in Article 4, Protocol 4, is not limited to expulsions from the territory, but should be interpreted and applied in light of its object and purpose as a procedural guarantee operating in connection with any measure of forced return conducted under the jurisdiction of a contracting state. In the past, the Commission has already considered that the refoulement of a group of persons who have not yet entered the national territory and who are kept at the borders falls within the scope of application of Article 4 of Protocol number 4, and I refer to the case DSSN BT versus France, a decision taken on 16th of October 1992. The Special Rapporteur of the International Law Commission on the Expulsion of Aliens shared the same view in his second report on the topic of July 2006. Especially the Special Rapporteur has included in draft articles prohibition of disguised expulsions, a term which indicates feigned or masked expulsions that are not carried out in execution of a formal measure and that seek to circumvent the relevant substantive and procedural safeguards provided for international law. Accordingly, a measure of interdiction of sea migrants on high seas, even if not based on any formal act, could fall within the broad meaning of expulsion under Article 4, Protocol 4, or could be seen anyway as a disguised expulsion under international law. The obligations stemming from Article 4, Protocol 4 remained overtly unfulfilled in the present case, as the applicants were forcibly handed over to the Libyan authorities as an undistinguished aggregation of persons without any consideration of their individual needs and without any kind of pre-screening or processing of their protection claims. The same sources I indicated before clearly indicate that the applicants were exposed in Libya to the risk of being collectively removed to their home countries for a group of nationalities without any individual examination. According to the CPT, collective expulsions are common practice in Libya. Tsegai Haptem confirmed this circumstance. Indirect removal, it is our view, to a country where the person concerned risk of being collectively deported should be considered in itself as a violation par ricochet of Article 4, Protocol number 4. Before concluding, I would just like to make a brief reply to the government objection concerning the alleged failure to exhaust domestic remedies. I must first of all respectfully emphasize that such an objection was not raised by the government in its observations before the Chamber, nor in its observations before the Grand Chamber. So it is the first time we hear such an objection, and the respondent should be therefore considered stopped from raising such an objection during the hearing. In any case, the objection is manifestly founded in light of the arguments which we have developed concerning the violation of Article 13. We have already indicated that in the present case there was no effective remedy in light of the relevant court case law available to the applicants in order first to claim protection on the vessels and secondly to oppose to their disembarkment and to avoid therefore to be exposed in Libya to the risk of ill treatment. Thank you very much, Mr. President.
Thank you, Mr. Sakuchi. Madame Kopari, Monsieur Sakuchi a soulevé...
Mrs. Sakuchi raised an additional point on the applicability of Article 4, Protocol 4. Would the government like to briefly respond to this argument? Thank you. Mr. Chairman, could you possibly repeat this? Thank you, Mr. President. Yes, I'll repeat my question. In its latest speech, Maître Sakuchi raised a point on the applicability of Article 4, Protocol 4, and I'd like to know whether, quickly, briefly, the government would like to respond to this additional point.
Vous avez bien compris.
Have you understood this question? Yes. As we have already noted, this question is not raised because this was our position, which has been put forward and repeated today. This is a question of logical incompatibility of Article 4, Protocol 4. It's a matter of interpretation, which should be raised before the court. As to the applicability of Article 4, Protocol 4, as we have already stated, the expulsion, the term expulsion as used in the previous cases, MSS against Belgium, Greece also, and other previous cases recalled by the applicants. And this has nothing to do with the present case. As we have already underlined on many occasions, there were no people on the Italian territory, or there was no illegal entry on the Italian territory. This is an obstacle which needs to be considered. And this is not an argument that can be used by the applicants, because the very purpose of Article 4, Protocol 4, which has been the source of well-established case law of the court, and this has nothing to do with the present case. Expulsion has a clear-cut definition, and this cannot be assimilated to the present situation of boarding a vessel at sea, so it has nothing to do with our situation. Thank you very much. Well, this leads us to the end of this hearing. I'd like to thank all the people having made a presentation, and the court will now deliberate on the merits of the case. The judgment will be delivered later. The parties will be informed of the date of delivery. I declare the hearing closed. Thank you.